Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about defamation. Cases that should have gone to the Supreme Court of Canada, but didn't. A home building company and homeowners had a dispute. The home building company thought they did a great job and they put pictures of the beautiful home that they built on their website advertising their services. The homeowners were unhappy with the company and unhappy with the fact that their home was being used for marketing purposes, and so they started to post negative reviews against the company. This led to the company launching a defamation suit against the homeowners, and the homeowners applying to have the suit dismissed under anti-SLAPP legislation that says that you cannot commence defamation lawsuits as a matter to stop people from engaging in public protest. And the case is very interesting because the Supreme Court of Canada ultimately denied leave to appeal. And the question of whether this actually engages the anti-SLAPP provisions is an important one. This isn't just a situation where somebody's commenting on a matter of public interest. For example, somebody who's commenting on a political matter or somebody who's commenting on a social issue. This is a private dispute between two parties, but it is in a public forum where companies have Google profiles and they have Google reviews and different reviews online. They use their homeowners' homes essentially for promotional purposes aimed at members of the public. So there is some public element to it. And then the question arises, where is the bounds of what constitutes public protest in the context of an anti-SLAPP legislation? And if anti-SLAPP is given such a broad interpretation as to prohibit actions for defamation against people for just doing things like posting defamatory online reviews, then isn't every case of defamation potentially something that could be susceptible to anti-SLAPP legislation? And then that doesn't that in turn defeat the purpose of anti-SLAPP legislation, which is to keep the courts from having to deal with meritless cases of defamation where people have a legitimate reason to advance their complaints on a particular public issue? All of this is very important issues for the Supreme Court of Canada to grapple with. The Supreme Court of Canada has previously heard anti-SLAPP related cases, but nothing that involves really private contractual disputes between two parties. And that's something that would be very interesting for the Supreme Court of Canada to weigh in on and really rein in the way that anti-SLAPP litigation is essentially being the new norm for any defamation suit that's being launched. Hopefully, the Supreme Court of Canada sees the way in which the expanding powers of this litigation and this legislation has had potentially a chilling effect on defamation lawsuits where they are legitimately brought, and considers taking a case like this again. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Please like, subscribe, and share with your friends.